Hello and welcome to this video on copyright. My name is Jason Harden. I'm the Manager of Access Services here at Trinity University's Coates Library, and I will be talking about copyright and related issues like exclusive rights and fair use. I'll talk about topics like piracy and artificial intelligence and the Creative Commons and things like that. So copyright is a huge subject area. There are a lot of things that you could go over, but I'm going to try to keep this brief and focused and keep the video as short as I can keep it. So having said that, to get started, what is copyright? Well, basically it's a guarantee on the part of the federal government that you as the creator of intellectual property have certain exclusive rights over that property. And I'll get into those exclusive rights in just a couple minutes. But before I do that, it's helpful to understand a little bit better what that term intellectual property means. Basically, intellectual property, or IP as we might call it, is anything that you create. It can be anything from art to literature, music, photography, or plastic and visual arts like sculpture, or even choreography. If you have choreography that you have designed and filmed or written in some sort of planned arrangement, then that is intellectual property as well. Now, there are three requirements for your creation, for your IP, to be protected under copyright. And that is, number one, it has to be original. It has to be your own creation, obviously. Number two is it has to be creative. It can't simply be some sort of regurgitation of factual information, because nobody can copyright, for example, the fact that France is a country in Europe, or that 2 + 2 = 4. I mean, none of that requires any sort of creativity to state. And finally, intellectual property to be protected under copyright law has to be set in some medium. It has to be fixed in what's called a tangible medium of expression to be copyrighted. So you can't simply just, hum a tune or sort of mentally compose a poem or something like that and call it copyrighted. You have to actually create it physically in some sort of medium. For example, if it was a photograph, nowadays most people take their photographs on their camera phones, they record their TikToks on their digital devices, that sort of thing. So those are copyrighted works because they're creative, they're original, and they are fixed in that medium of expression. They're saved to a digital drive or uploaded to a social media app or something like that. So before I go any further, I want to mention that copyright, and more specifically copyright infringement, is not the same thing as plagiarism. I have encountered this confusion a lot in the past, especially in higher education where students are taught to avoid plagiarism wherever they can. They can sometimes be confused between the concept of plagiarism and copyright infringement. Copyright infringement is simply when you undermine someone's exclusive rights. And again, I'll get into exclusive rights in just a moment. But it's when you encroach upon their ability to control, copying and redistribution or profiting from their work, etc., etc. It's literally when you copy without permission. Plagiarism, on the other hand, is a different concept. Plagiarism deals with the misrepresentation of authorship. So you can physically copy something without permission, which would be copyright infringement, but you can also misrepresent the authorship of that new work. That's plagiarism. There can be some overlap there. There's kind of a Venn diagram between copyright infringement and plagiarism. But just be aware as we move through the video and we talk about copyright and exclusive rights and things like that, that we're not talking about plagiarism. That's a related but distinct issue with respect to intellectual property and academic integrity and things like that. So I talked for a moment about exclusive rights that Title 17 affords you. And Title 17 is just the set of federal laws where copyright is encoded. I mentioned just a few moments ago that one of the requirements for a piece of intellectual property to be copyrightable is that it has to be in a fixed, tangible medium of expression. It's important to note that once that happens, once your creative work is set in some medium, copyright protection is automatic. You don't have to pay any fees, you don't have to register with the Copyright Office, although in certain circumstances it's a good idea to do so, it's beneficial to do so. Especially if at some point someone infringes your work and you want to take them to court over it, you want to file a lawsuit, you need to be able to have that copyright registration to demonstrate very rigorously that you're the IP holder. But it's not required. Copyright protection is automatic. Now, what are the exclusive rights that you have under Title 17? Well, first and foremost, you have the right to control the copying or the redistribution of your work. Okay, no one else can come along and copy your content and put it out there on the internet, or they can't photocopy something that you have in print publication. They can't redistribute that. Only you can do that. Secondly, if it's any kind of work that you could perform or publicly display, only you as the IP holder, only you as the copyright holder have that exclusive right. Nobody else can do that. So if we're talking about a thing like a stage production, or if it's a film work that you're going to hold a screening of, or if it's music that you've written that you're going to perform in concert, only you have that right to perform the work or to publicly display it. And finally, you as an IP holder have the exclusive right to create what are called derivative works. A derivative work is any kind of IP that builds substantially on a previous work of yours. So for example, when we think of derivative works, we think of things like sequels or adaptations of a work, or sometimes translations from one language to another. These are all examples of derivative works, and they are the exclusive rights that an IP holder has. There are some limitations to the exclusive rights that a copyright holder has under Title 17, and these are what we call fair use. And I'll get to that topic in just a minute. Before I do that, though, I'll mention briefly the term of copyright protection. Generally speaking, in the case of a single author, the term of copyright protection is for the life of that creator plus 70 years thereafter. So that might seem kind of weird, like what is the point of having copyright protect your work for your entire life plus 70 years beyond? Well, the idea there is that intellectual property, like any property, is something that you can pass on. You can bequeath it to either your heirs, your family, or something like that. Or most relevantly, in the case of copyright, you can bequeath it to a corporation or an organization. The classic example of this is Walt Disney and the Walt Disney Corporation. His works were his own copyright, but after his passing, they went to the Walt Disney Corporation. His very first creations, like the original Steamboat Willie cartoon, they passed into the public domain just in the last couple of years. But anyway, that's the idea behind the life of the creator plus 70 years, is that copyright protection can pass on from one entity to the next. In the case of corporate authorship, where you're dealing with more than one creator, like for example a film company, it's from the date of publication or date of release, for example, like in the case of film works, it's from the date of publication plus 95 years. So if the Walt Disney Corporation were to release a new Disney Pixar film this year, it would be the term of protection on it would be from here plus 95 years in the future. So once that term of protection is off, once it's either the life of the author plus 70 years, or in the case of corporate author plus 95 years, the work enters what we call the public domain, which is probably a term that you've heard before. And the public domain just means that the work enters it becomes the property of the world. So you can do anything with it. You can avail yourself of what would otherwise be the exclusive rights of the creator. You can reproduce it, you can distribute it, you can publicly perform or display it. You can create derivative works like sequels or adaptations or anything like that. For example, in the case of William Shakespeare, I mean, all his works have long since been in the public domain, and there have been a lot of film adaptations made of the works of William Shakespeare. So that's what the public domain means. Once something is in the public domain, there's no going back, so to speak. You can't renew copyright, you can't replace the original copyright, you can't do anything to sort of resurrect what has expired. Having said that, if you build on a work in the public domain and you put in enough of your own original content, whether that's commentary or adaptation or anything like that, or a new translation, for example, that can be copyrighted. It's just that the original work can't be. That copyright has expired. Okay, so now on to the topic of fair use. Fair use is encoded in section 107 of Title 17, if you ever feel like going there and looking it up and reading the actual language. But basically, fair use is governed by what are called the four factors. And the four factors are a set of criteria that are examined to try to determine whether copying was appropriate or excusable or fair in any given case. And they are, first and foremost, the purpose of the copying. Why are you doing the copying? And the reason this is important is that certain types of copying are more justifiable than others. Like, say, for example, especially in the case of higher education, some of the copying that you do is going to be defensible because you're doing it as a student or as a faculty member. If you were a student in a media class, for example, you might want to use a short film clip as part of a presentation, and that would tend to be considered as fair use. If you're a faculty researcher and you need to excerpt another researcher's work or diagram or chart in the process of publishing your own article, that would be something that might be considered fair use. So the purpose of why you're doing the copying is important. Secondly, the nature of the original work that you're copying from is important. And the distinction here is basically twofold. You need to think about whether the work is creative or whether it's factual. A creative work tends to be less fair to copy from than a factual work, because again, it's a creative work. It's something that has that aspect of intellectual property to it. Whereas a factual work, you can get facts anywhere. They don't require any sort of intellectual labor to come to. So the nature of the work is important if you're copying from something creative versus something factual. Secondly, in terms of the nature of the work that you're copying from, the publication distinction is important. Something that is unpublished tends to be less fair to copy from because the creator, the author, has the potential to market it, to publish it, to create derivative works, all of that sort of thing, but they haven't done it yet. So if you come along and copy from it or adapt from it or something like that, you have sort of preemptively violated that exclusive right that they would otherwise have. So unpublished works tend to be more sort of protected in that sense. Whereas a work that's already published or published and even maybe adapted or sequelized or something like that tends to be a little bit more fair to copy from. The third of the four factors pertains to the amount and substantiality of what you're copying. Amount stands to reason. That's pretty intuitive. How much you're copying is relevant. The less you copy, the better. So yeah, there's not much more to say about that. But substantiality is kind of a different concept. And what this describes is how significant your copying is, whether or not your copying represents sort of the core creative pieces of the original work. If you're effectively gutting the work, if you're taking out the most important parts, if you're taking out the substance of the work, that's going to be perceived as less defensible. And finally, the fourth of the four factors is the effect on the market value of the work. If your copying competes with the value for the work on the market, if you're potentially taking money from the rights holder's potential revenue stream, then that's going to be considered as less defensible. That's going to be considered as less fair. So those are the four factors under fair use. None of them trumps the others. Whenever court cases arise, whenever infringement claims are made, they are all sort of examined holistically by judges or juries in these situations. So each case is different. Occasionally I've been asked the question by students or faculty members, can you just tell me if this is fair use? They'll ask me, I want to do X, Y, or Z with this work in my work. Is that considered fair use? And in those circumstances, the answer is always, well, it depends. We need to have a conversation about it. We need to go through each of these four factors and examine it and try to make a good assessment on a case-by-case basis. Okay, so switching gears briefly, we're going to talk about piracy. Piracy is just a sort of more common word for copyright infringement, but it is more than just infringement. It pertains specifically, I think, when we hear the word piracy in the context of copyright, we think of late 20th, early 21st century mass infringement, specifically in the area of the entertainment industry, music recordings, film recordings, video games, that sort of thing. So that's kind of what we're talking about right now when I talk about piracy. Is I'm not talking about simply, maybe inappropriately taking a chapter out of a book to use in a school essay. And that's not what I'm talking about. When I'm talking about piracy, it pertains more to this sort of popular, broad-scale entertainment industry-related activity. As Trinity students, if you're watching this, you should know that the university has an appropriate use policy that has been developed by Information Technology Services, and I'm going to link to that in the description of this video. You should be aware of that. You're responsible for adhering to that policy. If you do not, if any of the activities that you conduct online using the university's internet are detected by a rights holder, and they do scour the internet for pirating activities, not as much as they used to 15, 20 years ago, but they still do it. And if it's detected, you could get in trouble. There are various sanctions, and those go beyond the scope of this video, but if you have any questions about that sort of thing and are concerned about any of your activities on the Trinity network, feel free to come to me, and I can help you sort of navigate those questions. During the late 1990s through the early 2010s, more or less, piracy was really a hot button issue in the US. There were mass infringement platforms like Napster and LimeWire and Kazaa, and the website, the Pirate Bay. All of these resources allowed for, very broad scale mass infringement of entertainment works that had been digitized, like music and movies and video games and things like that. The motion picture industry, the MPAA, the recording industry, the RIAA, as well as the Entertainment Software Association, which I think is what that stands for. I know it's ESA. They responded to this piracy with a lot of lawsuits, even down to the level of individual small-scale infringers. I mean, Back in the day, in the early 2000s into the early 2010s, there were all kinds of horror stories about college students being sued for many, many thousands of dollars for having downloaded things through Kazaa or LimeWire or Napster or something like that. So for many, many years, there was a lot of friction between the entertainment industry and the copyright holders that the industry represented and consumers, especially young consumers. And this sort of acrimonious relationship existed for a long time. By the mid-2010s, things had started to abate just a little bit. Fewer and fewer people were engaging in piracy, so it became less of an issue. Primarily, this had to do with the industry starting to offer more content in sort of an a la carte fashion. You could go to iTunes or to Amazon Music, and you could buy individual songs for very cheap. It was $1 or $1.50 per track. And you could download those MP3s onto to your player. So that made things more affordable than having to go out and buy an entire CD, which in the late 1990s, early 2000s, people still had to do, which was one reason that a lot of young people felt justified in pirating music, was they couldn't really get things sort of on the a la carte level. They couldn't get the granular content that they wanted. By the mid-2010s or so, the motion picture industry, the TV industry had started to develop streaming platforms like HBO Go and Netflix and Hulu and Crunchyroll and some of these other resources and services. And that cut down on piracy as well, because now people could have one monthly subscription that was pretty affordable, anywhere from $10 to $20 a month, and they could get a lot of the content that they wanted. For many years, Game of Thrones was a really highly pirated work, and once HBO Go was established, that cut down on piracy of that particular work. Over the past couple of years, there has been a slight resurgence in piracy, the degree of which I don't really know, but there are a couple of factors that have contributed to this. Number one, the streaming services have had a rise in subscription costs. Whether or not you view this as justifiable, it is what it is. Costs have gone up. Secondly, they have started to crack down on password sharing. So people have started to just pirate content rather than have to pay for their own, share a family account across different locations. So that has been one factor. And also there's been this increasing fragmentization of content. It seems like pretty much everybody has their own shows and movies now. Whereas the cable TV industry, you could have one cable subscription and get a lot of different channels and a lot of different viewing options and content. Nowadays, if you want to watch a given show, you need to be subscribed to streaming service X. If you want to watch another show, you have to have another streaming subscription. If you want to watch a different movie or movie series, you have to have a whole different movie subscription package. So that has been sort of the rationale, the justification among some entertainment industry pirates as to why they're going out and engaging in piracy again. I'm not saying that any of this is right or wrong. I'm just saying that this sort of resurgence has arisen in part because of changes in the streaming industry's practices and their platforms. But the bottom line with respect to online piracy as it pertains to Trinity University in particular is just don't do it. You can get caught, and if you do get caught, there are potential sanctions that you as a student might have to face, in addition to possibly being sued. Again, if you have questions about this, come see me and I can help you navigate these issues. Next, I'm going to talk about the Creative Commons. The Creative Commons is a nonprofit organization that has created a set of free, easy to use, alternate licenses that you can apply to your own intellectual property. Sometimes, occasionally, when you're out there and you're around the internet, and you'll see a little symbol that has, it's a little double CC symbol. That stands for Creative Commons, and when you see that symbol, you know that that work carries a Creative Commons license on it. It is different than your traditional Title 17 copyright, which has the, is the standard, Circle C that we all know. Creative Commons licenses are legally sound. They have been examined in court cases, so they are legally sound. They are free to use. They are international. And the Creative Commons website offers a very handy license generator. So if you want to go to the Creative Commons website and use their license generator, you can apply different stipulations and restrictions on the license that you want. But all of the licenses that they offer are more generous than traditional Title 17, so it encourages sort of a freer, creative environment for people to find your content and to use your content. Likewise, in terms of your own usage of other people's intellectual property, Creative Commons licenses that they place on their work are very helpful to you. And you can use the Creative Commons search engine. They have a search portal where you can find CC licensed content. And this is a very helpful thing that you can use to find CC content on, for example, Flickr or Google Images or ArtStore or various resources like that. The final topic I want to get into is artificial intelligence and the nexus of AI and copyright nowadays. This is a very ephemeral and shifting landscape. And no sooner do I make and post this video than I'm sure something will have changed. A new lawsuit will have arisen, or there will have been a ruling on one or more lawsuits. So all of this is very tentative still at this point, but just to sort of give you an outline on how things stand right now. First and foremost, it's important to know that artificial intelligence works cannot be copyrighted. The U.S. Copyright Office has interpreted Title 17 such that they say that only human creators can own intellectual property. An interesting case arose in 2022 that illustrated the complexity of this. There was a digital artist by the name of Jason M. Allen who created a digital art piece called Space Opera Theater. He actually titled it in French, Space Opera Theater, but I don't speak French and I'm not about to try to pronounce it and embarrass myself, but it was an AI generated work that he had used Midjourney to create, and he had used over 600 text prompts to get this image the way that he wanted it, and then he had used, I believe it was Photoshop thereafter to sort of put the finishing digital touches on it. He submitted it to an art competition, and he was given first prize. He won the competition. When he approached the U.S. Copyright Office about getting a copyright for that work, however, he was rejected. And he was rejected on the grounds that an AI work can't be copyrighted. His counter-argument was that his contributions to it were substantial. Those text prompts that he had put in to create it represented a significant amount of human input, as well as the final digital touch-ups that he made on it. So he appealed that decision that the Copyright Office had made, and ultimately he was rejected again. Maybe the most problematic aspect of artificial intelligence with respect to copyright, however, is the mass harvesting of intellectual property to train artificial intelligence programs. With respect to text-based AI like ChatGPT, these large language models have to be trained using text, using natural human language, real human language. And they will scour the internet, they'll go through and scrape the internet for human written text. So everything from like the New York Times to Reddit have been scraped by these LLM machines to train resources like ChatGPT. And some court cases have arisen, some infringement lawsuits have been filed saying that you can't do that. You can't use this text-based intellectual property to train an LLM. Even though the LLM's output can't be copyrighted, the original works that it was trained on are copyrighted. So that's the basis of that lawsuit, or those lawsuits. There have been several that have been filed. Also, with respect to visual AI products, these have to be trained as well. So AI image generators, like for example Midjourney, have to be trained on images. So things like Getty Images or DeviantArt, or even image postings on Meta, Facebook and Instagram, things like that. They're looking at copyrighted images to train the text-to-image generators. So that represents a potential for copyright infringement on a broad scale there. And copyright lawsuits have been filed along these lines. There are currently at least 20 major lawsuits pending in the area of artificial intelligence and copyright. And as of right now, as of late 2025, almost none of them have been resolved. Very, very few rulings have been handed down. So it's going to be interesting to see over the next few years how this issue plays out. So that's copyright very broadly. Again, my name is Jason Harden. I'm the Manager of Access Services here at Trinity University's Coates Library. If you have any questions about any of this content or suggestions on other topics that I could go into in more depth, feel free to reach out to me. Thanks very much for watching. Bye-bye.